Struggling to pay your child support? Are not receiving any? Need a modification? Has the Department of Revenue filed a case against you? Don't face this alone. If you are dealing with a child support problem, a knowledgeable family law attorney may be able to help you solve it. Let us help so you can focus on being the best parent you can be. Stress less. Choose more. Hey everybody, happy Wednesday. I am attorney Conti Moore Smith. I'm a family law attorney located in the Central Florida area, and I'm excited that you have joined us for our immigration update for the month. We've received great feedback about these updates, and we're so fortunate to have Frank join us. So Frank, if you want to introduce yourself, and then we can get right into it.
Thank you, Conti, for the invitation. I'm Frank Simforan. I'm a board certified immigration partner expert and founder of Simforan Surveyor Law. And I'm excited to be here. We were chatting off stage, I guess, about how cool it is to talk to people who are of your similar expertise and as much as you know as family law, Conti. It's just really a pleasure to talk to you about it and to pick your brain on these family law issues.
Well, we appreciate you making time for us. I see you all over the news now. So we are happy that you've made time for us and to help inform our listeners as to what's going on and what's an update with immigration. So if you want to kind of get started, we didn't meet last month, but kind of give us an update on what's going on with the immigration laws. Have you noticed anything unusual, new that our listeners or viewers need to know about?
Well, one big thing that I think users really need to know, one of the sad stories I'm seeing regularly now are people going to immigration court and being detained or going to state court and being detained. It used to be that state court or immigration court were sort of sanctuaries or areas protected, sensitive areas where the government previously would not go into. Unfortunately, that's not the case. Just about every day that I go to immigration court, there's immigration agents standing outside and just kind of waiting. There's also a state court. You're probably more familiar with this, Conti, but I know that there's reports. Obviously, there's a state judge in Wisconsin who was arrested for trying to help an immigrant or prevent immigration agents from detaining someone while appearing in court. So, I would just say strongly encourage people to seek legal counsel, retain legal counsel before going to court. One of the measures that the government is taking, even for people who have, applications for immigration benefits like asylum or any spouses who are U.S. citizens, et cetera, in many of the situations, the government is using a recent case to terminate their court cases, their immigration court cases altogether, and initiate this process called expedited removal. Immigration is one of these weird areas of law, Conti, where the cops, the law enforcement, the police can essentially, when someone's seeking to enter the country, they can function as judges. And so they can charge the person with being subject to removal after entering the United States without documents or without documents authorizing their entry. And they can also order the person removed expeditiously, immediately at the border without seeing a judge. So the cops, the law enforcement serves as the charging agent and as the judge. And in those situations, what the government has done is they've said that 2-year window, it used to be that you could only do that within 14 days of your entry. So if they caught you in the United States within 14 days of your arrival, they could do that. But if you've been here for more than 14 days, they couldn't do that. Well, what the government is now saying is that if you were ever detained within 2 years of your entry, so people who were sent to immigration court, who were given due process and allowed to proceed in front of an immigration judge, et cetera, the government is now going to court, Conti, and asking the judge to terminate those proceedings so that they can initiate this expedited process and deport people expeditiously. And these are for people who entered maybe 10 years ago and they were caught when they entered, like within 2 years of when they entered. And so they're going to court and terminating those proceedings. And now, even though you've been here for 10 years and what you would think due process protections have accrued from being here so long, they're saying, well, that doesn't apply because you were caught within 2 years of your entry. So even people who've been here for a really long time, if they're caught within 2 years of their entry, potentially could be detained under this expedited removal proceedings. So that's one crazy update. Another crazy update, which I mentioned off screen with you, was I recently had a client who was just about detained at an immigration appointment. When immigrants are released from immigration custody, they're usually given what's called a parole document or some sort of custody release document. And it has conditions, right? Because when the government enters, when a person enters the United States unlawfully or commits an immigration violation, their release from immigration custody, that many of them are issued a warrant and they can be arrested by law enforcement, right? By immigration agents. And so when they opt to release them, or when an immigration judge also orders them released, the release is subject to conditions. And one of those conditions is that the person cooperate with immigration officials in providing travel documents or meeting whatever requirements the government has for effectuating that person's departure from the United States. So in those situations, ICE agents can ask the people to make sure that they get their own passports. So in the event in the future, if they're ordered deported, immigration agents can effectuate that removal order. That's kind of a condition of their release, is to cooperate with facilitating their removal. Arguably, I think it's premature, because if the person hasn't been ordered deported, then you shouldn't be facilitating any removal. But the immigration agents are pushing hard on this and saying you need to, and they've said you need to turn in your travel documents. And of recent, they've also started pushing people to provide their children's travel documents, even if it's U.S. citizen children. I think there's real problems with this, but the way that they're justifying is they're saying, well, it's the parent's choice as to whether the child has to leave the United States with the parent, or if he made proper arrangements to have the child stay in the United States with a relative or custodian or some other guardian. And so if the person hasn't provided a guardianship document or some sort of custody document, which I know you can help them with,
talked about that the first time.
Yeah. Then if the person doesn't present that, then I think ICE agents have a plausible reason or cause to require that the immigrant provide the children's passports, even if they're U.S. citizens, because from their perception, if the person's being removed and they're children that have no custodian, well, the parent has made a decision to take the children with them, and so they can essentially remove the child with the parent.
Wait. Hold on, Frank. So you're saying that now they're making an argument that they can remove the child, even if the child's a U.S. citizen.
That's correct. I mean, I think it's then their justification is that it's a parental choice, right? Because if the parent didn't make arrangements for the child to remain here with a custodian, then in effect, they're saying that was a decision by the parent to, allow the government to remove the child with the parent.
So when we talked about on our first live that we did, we talked about a 751 chapter 751, where basically you could give temporary custody to a family member. That now is not just like a good idea; it seems like a necessity.
Absolutely. Yeah, absolutely. I mean, if you're under supervision with immigration agents, or if you're in removal proceedings, and you don't want immigration to potentially remove your children with you, even if they're U.S. citizens, I definitely strongly urge you to get one of these documents completed with UConn.
Because that's what started us doing this, was talking about that and us asking you questions about that. And so, so if you really want to have your ducks in a row, which you should, you want to make sure that you have a temporary guardian and the paperwork, I guess, ready and on you,
right,
to protect your children. That's crazy that children that are U.S. citizens can also be removed with their parents.
Yeah, and it's happening more and more. I mean, it used to be typically, the government policies were a little bit more, lax in terms of, allowing the person to leave the child with a family member or something like that. But now they're requiring these documents, as opposed to putting the person in some sort of state custody, right, for children without a custodian. So, and this is not hearsay. I mean, I was talking to an immigration agent, who I have a pretty good relationship with, and she was nice enough to call me because one of my clients appeared there, and they were requiring that specific document. So, very much a necessity, and people need to call you to get these things in order.
Okay. All right. Well, thank you for sharing that update. Anything else before we get into our questions?
The last thing I would say is that there's a new Board of Immigration Appeals case that came out on a couple of Fridays ago, about 2 weeks ago, which is it had a major impact in the immigration scene. It's one of the decisions that's sort of facilitating the new activities by the government in arresting people at immigration courts. Because essentially what this new decision said is that even if you entered illegally in the United States, and this is kind of groundbreaking. What it's saying is, if you're entered legally and you're caught, and they're essentially now saying if you're caught within 2 years, if the government releases you, first of all, the government has no authority to release you. That's what they're saying, and they're first saying that that they have no authority to release you because this immigration statutes essentially say that the person shall be detained. Pending any application for protection, for asylum laws, et cetera. If you have a claim for why you should not be removed, you can exercise that in custody. And they're saying that the government has no authority to release you. And the courts don't have jurisdiction to review those decisions because Congress has removed jurisdiction from federal courts as well as immigration courts. Yeah. So if you're caught entering the United States within 2 years, they're saying there's no authority to release you, and the courts can't intervene, can't do anything. And if you're released, the only authority under which you could be released is by virtue of a humanitarian type of parole by law enforcement. So essentially, if you're caught while entering within 2 years of your entering, what this decision is saying, you cannot be released unless the cops, who don't see their role as imparting justice or taking into account any kind of humanitarian situation, but now you're sort of making the law enforcement, the cops, the guardrails of anybody's claims to humanitarian concerns or humanitarian considerations. Yeah. So you're going to have to convince the police to release you for a humanitarian reason. And that's, you can't go to court to do this. So this is groundbreaking, and it's positive in some ways. It's horrible in many ways, but it does have one sort of flip to it, which is a positive one. The positive one is that many people who entered illegally used to not be eligible to adjust their status because they had entered illegally. So if you married a U.S. citizen, or if your child's 21 and you wanted to fix your status to green card, you couldn't fix it because of the way that you entered. Most immigration laws require that you have a legal entry in order to change status. Well, this decision essentially says, because the law allowed you to legal entry, which means either a legal or an admission as a visa or a parole. So what this rule does is it allows people who potentially entered illegally, we thought at the time, now it makes an effect. It has the effect of turning their illegal entry into a legal entry because they were paroled for humanitarian reasons, right? So if they were released for humanitarian reasons by law enforcement, because that was the only authority that the government had to release them, because the law says shall detain, then that means that the person now is eligible to adjust. So many people in the community who used to have to file waivers or weren't able to fix their situation can now adjust their status, potentially can, if they're married to a U.S. citizen, if they have a child who's a U.S. citizen, if they have a parent who uses a citizen, et cetera.
So they need to contact you to see.
They should contact us to do that. Yeah. And if they have assets, they should consider a prenup, if there's assets, to see ways that you can help them protect their assets.
Okay. Well, yeah, we'll talk about that. We had a question about that we didn't get to. So let's get to our first question. Can a non-citizen parent be required to pay child support in the U.S.?
Yeah. So, yeah, absolutely. From an immigration standpoint, absolutely. I mean, I think this is more of a family law question. Immigration standpoint, the immigration status is separate from the state custody and child support obligation. So you can answer that more confidently.
Yeah. So, I mean, anyone so in family court, we're not going through and checking immigration status before we move forward with, a court order or requesting relief for child support. So yes, whether you're a citizen or non-citizen, you can be put on child support in the U.S.
Yeah. I think the most interesting part of this, question perhaps is more, if the person is abroad, then you may have some issues as far as how to enforce that child support order, right?
And that's the issue, is about enforcement. It's hard to enforce it in different countries. You can still get put on it. And if they try to come back, they could still, have those consequences, and interest can still accrue, and all those things can still happen. But if you are trying to enforce it in a different country, that's a whole different issue. But you can still be put on child support. Yes. Okay. In the country or abroad. Okay. Can a step parent sponsor their spouse's children from a previous marriage for a green card? Frank, that's for you.
Yeah. So the answer is yes, so long as they maintain a bona fide stepchild, step-parent relationship. So there's a little bit back and forth on that, but I think the overwhelming case law on that is clear that can happen as long as the step-parent maintains a bona fide ongoing relationship with the child, even after the marriage ends. And sometimes they require evidence of that, but yeah, we do it all the time.
Okay. All right. The next question that we have, are there risks in signing a prenup that might affect spousal support, especially if one spouse is undocumented? So with a prenup, in a prenuptial agreement, there are certain things that you can negotiate and work out. You can talk about assets. You can talk about spousal support or alimony, all those things. What you cannot do in a prenuptial agreement is say, well, time sharing is going to be this with the child, or child support will be this. That is going to be left to the judge to determine what's in the child's best interest. And in Florida, you cannot waive child support. Child support is a right that belongs to the child and not the parent. So there's a couple of restrictions that you have as far as a prenuptial agreement is concerned. But with the prenup, it could, like if you're saying you're not going to pay spousal support, then that could limit, or if you can agree to what the amount would be if you were to pay it, that could help you with some liability, limit your exposure, if you will, as to how much you could pay for alimony. But the flip side of that, and we talked about this the first time that we went live, Frank, was if you sign an affidavit saying that you're going to support someone financially to come to the U.S. What is that affidavit? What is the name of that affidavit?
So it's called an affidavit of support, and it basically makes the government, United States government, a third party beneficiary to that contract, or party to that contract. It essentially guarantees to the United States government that you're going to maintain that person financially, support them financially, to the extent that it's necessary, to the level of 125% of the federal poverty guideline. So from my perspective, and you can speak to whether that's my understanding, and you can clarify that, Conti, from a family law perspective, that you can't really waive these requirements. It's impossible. Even in bankruptcy court, my understanding, there's no case recorded where these requirements were waived. But there's still a benefit to the alimony, because it's only 125%. So if in alimony, you might have been required to pay, 200% of the poverty guidelines to the spouse. Well, then under the affidavit of support, you would only be responsible for 125% if you had a prenup that restricted that. Exactly.
Right. So July 1, 2023, the law changed to where now we have a formula for alimony. So to not go into too much details, but essentially you're going to look at the net income of one spouse and subtract the net income from the other spouse. And the most that you could get would be 35% of the difference. So an example would be if spouse A is making $100,000 and spouse B makes $0. 100,000 minus 0 is 100,000, and then the most they could get would be 35%, so 35,000 annually. And then if you're married for less than 10 years, then you can get it for 50% of the length of the duration of the marriage, so long as it's more than 3 years. If you're married between 10 and 20 years, you can get it for up to 60% the length of the duration of the marriage. And then if you're married for more than 20 years, you can get 75%. Of the length of the duration of the marriage. So if you're married for 10 years, then you would get it for 5 years, 50%. And so we can assist you with figuring that out, but having a prenup could absolutely help with your exposure, because the poverty guideline is a lot, lower depending on the income of the parties than what you could end up having to pay in a family court for alimony.
Right. Makes a lot of sense to have a prenup.
No, absolutely.
And I guess the question, part of that question is, would it have an effect if the person's undocumented? No, because it would restrict. I mean, it can't waive the affidavit support requirement, but it wouldn't negatively impact the person. It would just sort of establish this, perhaps a ceiling of how much the person would be responsible for an alimony.
Absolutely. All right. The next question is, how can a non-citizen spouse who is being abused by their U.S. citizen or green card holder spouse protect themselves without risking deportation? You can kind of get started on what your thoughts are, and then I can chime in.
So, I think so. In immigration, there's a special law for this. It's called the Violence Against Women's Act, and it allows the non-citizen who's the victim of any sort of physical or extreme mental cruelty to essentially self-petition the United States government for immigration status. And so there's definitely that. You can file that petition. Obviously, you have to have some evidence of the abuse. The more evidence you have, the better. Whether you have arrest records, or you have text messages, or whether you have any proof of the person being controlling, ostracizing the person, not allowing them to see families, or whatever form the abuse takes. You have to present evidence of that. It's important to note that the standard for those are a little bit lower than the average case. It's not a preponderance. It's a little bit lower because it's difficult for people who are victims of abuse to present a lot of evidence. So the government will accept anything that you have to prove that. And that essentially does allow the person to petition for themselves and get permanent residency status. So it's very important to meet with an attorney, probably to develop that case, to preserve evidence about the abuse, and to present that. And you can file that even while you're with the person. If you're too afraid to leave them, or you don't feel emboldened enough that you would get protection from other authorities, etc., then you can still file it while you're with them, and the government allows you to designate a safe address. Your attorney can be your safe address, or you can have a P.O. box. You can have other places where they can mail all your information, so the person doesn't control. That's part of the control oftentimes is, the immigration stuff, and sort of saying, I'm not going to file your papers, or I'm not going to do this if you don't do this. So if you can, have those documents sent to a safe location or to an attorney, that, could potentially help with that as well.
That was good to know, to learn that from the immigration side. With a lot of abusers, it's manipulation. Like you said, it's the control. You won't get this. I won't support you. You'll go back here and all that. It's important that you speak with professionals. It's important that you not rely on what that person's saying, and you find out for yourself. So whether that's borrowing your friend's phone to call us, or to call Frank's office, whatever you have to do, you need to make sure that you get real information, and that you don't let them just continue to control and manipulate the situation and you. So it's important to talk to us. It's amazing what I hear in consultations, what the other spouse in these situations tells the spouse that's being abused. And so you really need to get real information to get help, and borrow your friend's phone, or go somewhere and call from another phone if you're worried about them having access to your phone.
Right. Yeah, absolutely. Yeah.
All right. Well, anything else? This was great. I learned something. So thank you, Frank, for continuing to enlighten us and our team and our viewers. We appreciate you. If you need any family law help in the Central Florida area, please reach out to us at 407-831-0203. And Frank, please tell people how to find you.
Any immigration assistance, you can call us at 407-802-1717. Or you can visit some foreign surveillance law, but probably the easiest, since if you don't want to spell my name, it's to call 407-802-1717. But yeah, Conti's the best at family law, so I encourage anybody with any family law issues to reach out to her. Her team, she's got a big team of all-stars, and they do a tremendous job for people.
I appreciate you. And I encourage everyone to call you as well. We are also now taking Spanish-speaking clients for family law issues. So please reach out to us, and we will be happy to assist you. And I know that, Frank, you also speak Spanish as well, correct?
I do. Yeah.
Okay. All right. Well, thank you all so much for joining us. Thank you so much, Frank. We appreciate it. We'll be back next week or next month, not next week. We'll be back next month. If you have any family law and immigration topics that you want us to go over, please comment on the video and like the video and make sure that you subscribe to our YouTube channel. Everybody have a great day.
Take care.